Hi guys, it's Kathy. I hope you're doing well. Just so you know, I've been live on Twitch for 30 seconds more because YouTube would not start this morning. I don't know what happened. But yeah, I can see they're chatting. I can see it. I just couldn't get YouTube to start. I'm looking at my Twitch chat. Alright, Eileen, it doesn't matter if you have old Discord accounts, especially if they're associated with emails that you don't have that aren't yours anymore. You can just leave them and ignore them and forget about them forever. You can just start a new Discord account. You can go to Google right now and create a new email account and then get in Discord right now, no problems, easy peasy. And that's what I would do if I was you. I would just get a new email and then start a new Discord and forget about all the other ones. Don't write it down. Just, you know what you need? You need one of those software, one of those like KeePass. You need a password vault that saves all the information for you. It'll save the site, the URL, your username, and your password. So you just go there and you just click in KeePass and it'll take you right there and log you in for you. It's really lovely. I'm not saying get KeePass. I'm saying get something like KeePass. Or get KeePass. I mean, you can get KeePass. No one's stopping you. But that'll be the easiest way. If you're just worried about old accounts that you have on Discord, don't. Don't even worry about it. It's fine. Thank you. Thank you, Joshua the cat. Thank you. I don't have my other screen up yet, so it didn't flash on the screen. You gotta wait. Premature. Premature sharing of bits. Alright. So the first thing I had for you today was it was a clip from Victoria, not the Victoria, even though it was just her birthday. Happy belated birthday, Victoria. We all missed her birthday. Yesterday, I think it was. Listen, my days are really mushing together. It could have been the day before. It was very, very recently. Victoria just had a birthday. And if she ever watches this, happy birthday, Victoria. Victoria, Australia. I had a clip from Victoria, Australia, from that courtroom. I did email Auckland, did I say that right, Auckland, and asked for a link to their Zoom. They said no. They said we don't Zoom. There's nothing we have available to send you because we do not Zoom. So, JK was right. I cannot get Auckland. I figured Auckland would. Yes, Victoria just had a birthday. It was either yesterday or the day before. I think it was yesterday, though. Victoria had a birthday. So, happy birthday, Victoria. But it was really sad. This kid was drunk and high and got into a car and ran over a bunch of people and killed one of them. But that's not why. My cat just knocked my camera out. Don't worry, it'll come back. But that's not why I didn't play it. It was only like 25 minutes, but man, for me it felt like 3 hours. And I'm able to sit through boring easily. So we are not playing that. So then I thought, okay, I'll go to Georgia to one of those habeases. There was a habeas, and you know how good they usually are with them fighting with no understanding of the law. Well, they put this freaking doctor on the stand, and he was so boring. Come on, camera. He was unbelievable. This guy curb stomped this other inmate, and then the other inmate died like an hour later. That should have been not exciting, but that should have been fine to watch. No. This doctor was saying how there was no possible way this guy did it. It was the EMTs doing CPR that actually did it. Maria, happy birthday, Victoria. And I'm sure it might have been interesting maybe to Nan, but I don't think so. Because it was like an hour long of just describing the heart. So that didn't work. And then, I rapidly ran out of time to find really good. So we are going to Judge Saber, 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 however you pronounce that. For this guy, who doesn't scream and doesn't fight, he's quite the opposite. And he gets pretty emotional on stand. But that's what we're going to see today. Oh, you know what? My Twitch chat isn't running right. Wow, I should fix that quick. And there we go. No, that's not running right. All right, let's try this. I know this is going to look weird for a second. There we go. There we go. That's better. Now my Twitch chat is running. And now we're going to press play. I didn't hear sound a second ago when I was just looking at it. So I'm a little nervous. No sound. It's fine. Yay, thank you. Maybe he just has it muted. Let me. There we go.
2402 F22 and 50D032311 F212, State of Indiana v. Johnny Witt Jr. He's present with us in court in person, as well as by his attorney, Mr. Hoover, and the state's here by Chief Deputy Prosecuting Attorney Nicholas Langowski. We are scheduled for a submission of plea and sentencing in both of these cases, and there was a written agreement that outlines the terms to the court, and it's anticipated we go forward with that agreement. Now, Mr. Witt, we have been discussing this at prior status hearings, and what it does mean today is that it's anticipated you go forward with your plea in both of these cases pursuant to the plea agreement, and then you'd be sentenced in accordance with the terms. Is that why you thought you were coming to court today?
Yes, Your Honor.
Can you please raise your right hand?
Yes.
Do you swear or affirm under the pains and penalties of perjury to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Please state your full name.
Johnny Paul Witt Jr.,
What's your date of birth?
8/17/1970,
What are the last four digits of your social security number?
8264.
The agreement I have is in written form and it's filed in both cases. Mr. Hoover has just pushed a computer in front of you. I presume that you have a copy of the plea on the screen. Mr. Witt, are you following along with me at the plea?
Yes, Your Honor.
Did you read through that plea, understand the terms, and then sign it?
Yes, Your Honor.
Do you have any questions over those terms before we go forward?
No, Your Honor.
Did you also read through, initial, and sign the various rights listed in the acknowledgement of rights form?
Yes, Your Honor.
And you did not sign paragraph 6, which reads, I have the right to petition the court for treatment as a drug offender. I waive that right. And is it effectively that you didn't sign that because you are going to be asking for some sort of treatment today?
Yes, Your Honor. I'll be asking for RWI program.
Okay. That's a fair point. And, paragraph 6 is a specific term of art, so I understand why you did not sign that. Listed in paragraph 1 is that you have the right to a trial by jury.
I don't know what yellow means. I don't know what yellow means. I suspect with this guy, cowardly. I suspect that this guy means he's Oh no, not a trusted, a trustee, a trusted inmate. It means he's doing really well. I suspect, but I'm not sure.
At that trial, you'd have the right to see and hear the witnesses testify against you and ask questions of those witnesses. You'd also have the right to require the state prove your guilt beyond a reasonable doubt. And at the trial, you'd be permitted to bring witnesses in to testify in your defense and force those witnesses to come in using the court's compulsory process. At the trial, Mr. Hoover will be representing you as he's been representing you throughout these proceedings, as well as you'd have the right to remain silent at the trial. Additionally, you'd have the right to an appeal of both of these cases. Do you understand that you have that set of rights, sir?
Yes, Your Honor.
Do you understand that you'll be waiving those rights in both cases by operation of you pleading guilty today and being sentenced?
Yes, Your Honor.
Additionally, have you gone over the terms of this plea, spoken to your attorney, Mr. Hoover, and decided upon this course of action independently with your review of Mr. Hoover?
I have, Your Honor.
Is anyone forcing you or threatening you in any way to go forward?
No, Your Honor.
Do you understand by going forward with the agreement, you will be pleading guilty to 2 of the offenses, meaning in each of the cases, 1 offense in each case?
Yes,
Let's speak about the general terms of the plea itself. It outlines that you'd plead guilty to count 1 in 50D03 2311 F212, and that is charging dealing in methamphetamine as a level 2 felony. You'd also be pleading guilty to count 1 in 50D03 2402 F22, also charging dealing in methamphetamine as a level 2 felony. Bracketed there to the right has an indication that the parties are free to argue concurrent versus consecutive sentences. And so there'll be an argument as to whether those convictions and the sentences will be entered concurrently or consecutively. I'll speak about that in just a moment. Paragraph 2 is blank in that there's nothing being dismissed. Paragraph 3 indicates that there is a 17.5 year cap on the executed sentence in this case. And so that is the upper limit of what the court can sentence you to in both of those cases listed there. Additionally, as it's indicated with that other ellipsis or bracket, this is all other terms up to the court's discretion. Was that your understanding of what you've agreed to?
yes, Your Honor.
Effectively, what that means is that the sentencing range for the 2 level 2 felonies is capped at 17.5 years. Do you understand that?
Yes, Your Honor.
Now, typically, the sentencing range would be 10 years up to 30 years with the advisory sentence of 17.5 years. And by operation of that cap, it lowers that upper limit to the 17.5 years. Understood?
Yes, Your Honor.
Do you also understand the difference between a consecutive and concurrent sentence?
Yes, Your Honor.
Do you understand by going forward with the agreement that has been filed, the court will make a decision of whether this will be consecutive or concurrent to each other?
Yes, Your Honor.
Just as an aside as well, and we'll get into this in further detail, but I'm also required to make a determination of whether this would be consecutive or concurrent to any other sentence as well. I note that there may be one outstanding in Stark County, and so I'll have to make that decision as well of whether it be consecutive or concurrent to any other sentence that may be outstanding. Understood?
Yes, Your Honor.
Do you have any questions over the nature of the plea?
No, Your Honor.
Do you believe going forward with this plea is in your best interest?
Yes, Your Honor.
And why is that?
I mean, I've been 21 months today, Your Honor, and I'm just ready to move on. Whatever I need to do to get these things taken care of and get home to my family.
Before I go forward with your plea, do you understand what you are charged with in both of these
Hi,
cases?
Shannon. Hi,
Do you understand the
Shannon.
nature of the level 2 felony and how it is charged as a level 2 felony?
Yes, Your Honor.
Anything else to add at this point, Mr. Hoover?
No, Your Honor.
Then, Mr. Witt, as it relates to the plea, we'll start first with the first listed case, which is the 2311. As to the charge of dealing in methamphetamine as a level 2 felony, as contained in count 1 of 50D03 2311 F212, how do you plead this morning? Guilty or not guilty?
Guilty, Your Honor.
Are you under the influence of drugs or alcohol currently?
No, Your Honor.
Do you understand what you're doing here today?
Yes, Your Honor.
In regard to that factual basis, the information that was filed in this case has a date of November 15, 2023, here in Marshall County, state of Indiana, where it's outlined that you did knowingly or intentionally possess with the intent to deliver methamphetamine, pure or adulterated, said methamphetamine weighing at least 10 grams. Do you agree you committed that offense as it was charged?
Yes, Your Honor.
In regard to the factual basis, Mr. Hoover, and Mr. Langowski for that matter, is it based on a prior offense of dealing? Or as charged, is that what the charge is based on? Maybe that's particularly a question for you, Mr. Langowski.
This is in 2311.
2311 F212.
No, it would be based on the weight.
Mr. Hoover, any further questions on that factual basis?
Not on that factual basis, Your Honor.
Do you think there is a sufficient factual basis for that offense?
I also have a follow-up question on the second factual basis
Oh,
for
okay.
purposes that go towards consecutive versus concurrent.
As it relates to 2402 F22 is what you're saying?
Yes.
But as it relates to 2311 F212, you think there's a sufficient factual basis with that additional question in the other cause?
Yes.
Now, Mr. Witt, as it relates to that other cause, which is the 2402 F22 cause, where it's outlined in count 1, dealing in methamphetamine as a level 2 felony, how do you plead to that offense this morning? Guilty or not guilty?
Guilty, Your Honor.
Now, that offense has a different information and a different allegation date. And Mr. Hoover, if you want to lay the factual basis, you can, based on what you just indicated, or I can simply go forward with how I would normally do it.
I can do it, Your Honor.
Sure, go ahead.
Mr. Witt, taking you back to November 29th, 2023, were you in the state of Indiana, Marshall County?
Yes.
And on that particular date, did you in fact knowingly or intentionally deliver methamphetamine to someone?
Yes.
Okay. And you agree that the amount was a weight of at least 10 grams?
Yes.
Now, this person that you delivered it to on November 29th, 2023, was that in fact the same person that you delivered it to about approximately 2 weeks prior on November 15th, 2023?
Yes.
Okay. And this is a person that you had done a couple of deals with in a short amount of time, correct?
Yes.
Okay. Nothing further, Your Honor.
Further questions on the factual basis, Mr. Langowski?
Yes, Your Honor. I actually have I have a question on. It pertains to both cases. Mr. Witt, on both separate transactions, they were both substantial amounts of weight, correct?
Mr. Langowski, I can't help. Can you clarify what
Yes.
substantial amounts of weight means so he
On-
knows what he's answering?
On 24 or in the 2402 F2 case, the deal on September 29th or November 29th, I apologize. You intended to sell just over 28 grams of methamphetamine, correct?
I intended to sell an ounce of meth.
And an ounce weighs how much?
They say 28 grams.
So 20.
So the answer would be yes. So Zach shared my clip with Law Talk with Mike yesterday, the one with the naked girl. And he played it last night, and he shouted us out. Mike did. He shouted out us over here. It was great. It was really cool.
28 grams.
Thank you,
And
Zach.
then on 23 or 23 11 F212, Was that also an ounce of meth?
I'm not for sure on what the weight of that was.
If I told you that it weighed 27.9 grams, would you have any reason to doubt that?
I don't think you'd have any reason to lie to me. Like I said, I don't know what that would have weighed.
So you would have no reason to doubt that weight.
No, sir.
I have no other questions.
Further questions on the factual basis?
Nothing on that, Your Honor.
And I presume in 2402 F22, you believe there's sufficient factual basis, Mr. Hoover?
I do.
Mr. Witt, as it relates to both of these causes, do you have any further information about the facts of the case you'd like to offer at this point?
Just, Your Honor, that the same person that I sold to twice.
Well, technically, he said Zach was to blame, which was great. Then he said Zach got it over there at Court Vibes. I don't know if he said Kathy was to blame. That might have been a different clip.
The gentleman involved in this is same person on both of them, Your Honor.
But the moral is Zach is to blame.
Thank you,
That's
Mr.
the
Witt.
whole moral of the story.
I'll accept the pleas and find that there's a factual basis and impose the convictions for the dealing in methamphetamine charge as a level 2 felony in 50D032311 F212, as well as the charge of dealing in methamphetamine and conviction as a level 2 felony in 50D032402 F22. I'll move into the sentencing phase of the hearing. And to begin, Mr. Witt, there was a pre-sentence investigation and written report that was filed with the court. Did you have an opportunity to review that?
Yes, I did, Your Honor.
Were there any errors, corrections, or omissions you wanted to bring to my attention?
When I looked through it, no.
You would agree it's substantially accurate?
Yes, Your Honor.
Were there any errors from the state's perspective?
No, Your Honor.
And I presume, Mr. Hoover, you didn't have any either.
No, Your Honor.
Mr. Langowski, are you anticipating submitting any evidence in support of the sentencing argument from the state?
We just ask that you take judicial notice of the probable cause affidavit. Understandably, they are in the pre-sentence investigations, but we just ask that you take judicial notice of this.
I'll take notice of those two probable cause affidavits in the cases. What evidence would you be submitting, Mr. Hoover? And I would note that there were a couple letters/certificates that were submitted in e-file, so I'll be presuming to accept those as part of the defense sentencing. But other than those letters, what else would you be offering?
Your Honor, we have Brittany Tremaine to testify on behalf of Mr. Witt.
All right, Ms. Tremaine, can you come on up? You can go through the door and the railing there. Before you have a seat there, please raise your right hand. You swear or affirm under the pains and penalties of perjury to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Have a seat there, ma'am. Mr. Hoover?
Thank you, Your Honor. Mr. Tremaine, can you state your full name for the record
Brittany Tremaine,
and where are you employed at?
the Marshall County Sheriff's Department is the program director in the JCAP,
And what is JCAP?
the Jail Chemical Addiction Program.
And what all is part of that program as far as the education that's given?
They have classes in dialectical behavior therapy, cognitive behavioral therapy, 12 steps in relapse prevention. There's also a number of elective classes in which they can also choose to participate. And while programming, Mr. Witt participated in an MRT, job and life skills class, AA, NA, Smart Money, and Celebrate Recovery, as well as having individual sessions with myself.
So you kind of anticipated my question there. I was going to ask you how Mr. Witt was involved. So you listed a number of things that he did.
Correct.
I guess, can you start with MRT? First off, what is MRT and how did Mr. Witt do in that component?
MRT is moral recognition therapy. It is a more intensive version of cognitive behavioral therapy that is ran by an outside volunteer that comes in to complete that, as you have to have a different type of training apart from what I do from the class setting. He began to participate in that. He did not yet complete that. However, he was very close to completing it and has worked very hard. He did graduate JCAP on July 7th of this year.
So to be clear, he was able to graduate JCAP without completing the MRT component.
Correct.
And why didn't he complete the MRT component?
He had graduated and there was a bed issue and there was a little bit of a finagle there. So he was removed back to general population. Should improvements be made, though, the suggestion was made that he can come back and finish it. Just at this time, there is no room in the pod to actively do that.
Understood. You mentioned there were some other components that to the classes that you took as well, correct? What was the next one that you had mentioned?
Job and life skills class. Again, these are all have outside volunteers that come in. That is a class that gets them prepared, goes over job resumes, things that they might be able to do too. So when they are able to transition from incarceration back to outside life, we can help bridge that gap. And there's the gentleman who runs that was formerly with Work One. So we have a lot of connections to help them maintain and achieve jobs. So that way they can continue to be productive members of society after incarceration.
And did Mr. Witt in fact complete that component?
He did.
And then what was the next one that you had mentioned?
Alcoholics Anonymous and Narcotics Anonymous, in which he both completed it as well.
And were there any other components then?
Smart Money and Celebrate Recovery. He did complete both of those as well. Smart Money is ran by First Federal. They come in and they teach them how to better finance themselves. If they've dug themselves a hole in credit, how do they help them build that? And they kind of go through things with them step by step to better themselves. And then with Celebrate Recovery, again, that's just more of an intensive or self-reflective class that helps him kind of understand where he went wrong, where he needs to be, and how to continue down that right path.
And specifically, Ms. Tremaine, what was your role with Mr. Witt?
I taught him in dialectical behavior therapy, cognitive behavioral therapy, 12 steps, and relapse prevention.
And I guess in your time with him, did you notice any type of change over the course of the program?
I did. There are several things that stuck out to me while Mr. Witt was programming. He's been able to recognize how this continued cycle of addiction has led to nothing but turmoil, not only his life, but the lives of his loved ones. He's also identified how his addiction he has continued to make broken promises in light of those most important to him, as well as causing himself mental and emotional instability. He was able to reflect on his past sobriety and identify the importance of having a routine and making sure he makes it to AA and NA meetings, as well as keeping in constant contact with a sponsor. He's also given many positive supports, has been given many positive supports to reach out to throughout programming, and he has realized he is his own worst enemy when it comes to his addiction. He shared that he would like to participate in the RWI program with me during programming to continue his sobriety and learning even more tools to help him once he's released from incarceration, so he can continue to work towards becoming that productive member of society in which he wishes. Mr. Witt was also able to identify traits he picked up while growing up in an alcoholic home, as his father was an alcoholic and at times would become aggressive with his mother. He also learned to deal with emotions just like his father did, using substances to take away the emotion or pain which he was encountering at that time. He's also been able to identify high-risk situations in which he may face, such as old friends, visiting establishments where he participated in addictive behaviors, family stress, putting others before himself, biker events, and the casino. Mr. Witt has also learned to set healthy boundaries while in programming, and relationships will assist him in staying on the right path. He's increased his positive coping skills to deal with life stressors so far, to include meditation, coloring, taking a walk, talking to someone he trusts, playing cards, listening to music, watching television, praying and or reading the Bible. Mr. Witt is also now able to identify emotions in which are the biggest triggers for him to deal with, and he can now deal with them in a more productive way rather than defaulting to substances or anger. Mr. Witt also recognizes now more than ever that the past is the past and he cannot be changed, and that he has to remain in forgiveness with himself for his past actions, which has allowed him to move forward and remain focused in his recovery. He's also come to understand the importance of stop, think, listen, and plan before acting, so that way he reduces his impulsivity. He has also been able to identify feelings that result in anger, such as past abuse, lost loved ones, loneliness, and things he has lost, his addiction, and people who have wronged him. Mr. Witt was furthermore able to identify how he can deal with angry feelings in a more positive and constructive manner, such as stopping to think about why he is feeling the way he is and process to see if his anger is a secondary emotion to another emotion in which he is experiencing. He's also been able to identify several positive supports which he can reach out to, several which are currently sitting in your courtroom, and several who are also not. He has also been able to create a relapse prevention plan as well as a backup relapse prevention plan should things not go as planned, that all contain positive coping skills, healthy support system, and skills he's learned that he can utilize in times of distress. And most importantly, he was able to identify his triggers, which will allow for early intervention so he does not fall back into old patterns of behavior, as well as why daily work on recovery is essential for his continued recovery.
So, Mr. May, I guess moving forward for Mr. Witt, what would you say is the most important thing for him?
To continue staying in the recovery aspect. I know earlier he mentioned wanting to attend RWI, and I think continuing to build those skills is going to be the best thing that Mr. Witt can do for himself, is continue remaining recovery. So he continues to hold himself accountable.
Thank you. I no further questions, Your Honor.
Mr. Langowski.
Thank you, Your Honor. At what point in the recovery world would you consider that someone's not an addict and that they're just a dealer?
I think in some way it's all an addiction. Some people are addicted to the drugs themselves and doing that. Other people are addicted to the lifestyle of the fast money. But the real question is that person ready and willing to change? And at this point in time, I believe Mr. Witt is willing and ready, where he was not willing and ready like
What-
he is now in the past.
What if someone has now 6 dealing convictions?
We are human and we make mistakes every day. It's just a different type of capacity. If he's willing to
And-
make a change now,
What if it's not small amounts of weight to support his habit?
Mr. Langowski, can you clarify what you're asking?
I'm asking at what point do we differentiate between an addict who is supporting their habit and a pure drug dealer?
I follow that, but clarify specifically as it relates to that weight.
Most dealers who are supporting our habit are dealing in small weights. Would you agree with that?
correct?
And then when you get to larger weights, you're merging into the area of pure drug dealing. Would you agree with that?
Correct.
So at what point do we differentiate between someone's a dealer versus someone's an addict?
I think that's just something that would have to, are they using their product while they're dealing? Is it just strictly dealing and not using? Because most of the two typically tend to coincide.
And Mr. Witt was removed from JCAP at one point, correct?
Correct.
And what was that for?
There was a incident report where he was disrespectful to staff. That is something I do not tolerate. I do have the option for them to have a second chance in the program, but they have to go back to Gen Pop and they have to show through actions that they are willing to make changes, in which he did so while he was housed in general population. So he was brought back into the program on December 9th after being terminated on August 18th of 24.
I have no other questions.
Redirect on that?
No.
Might be an odd question, Mr. Tremaine, but
Okay.
is it correct in what I've heard you say is that your interaction and knowledge and exposure to Mr. Witt is strictly through your JCAP program, meaning you didn't know him prior to him being arrested and incarcerated at the jail?
Tim, no.
And you answered my question because I was going to ask you about the exact, as you put it, there was some finagling, and I was going to ask you about that. You indicated there was some sort of discipline or some action by the jail that removed him from JCAP.
Correct.
That raise any questions, Mr. Hoover?
No, Your Honor.
Mr. Langowski?
No, Your Honor.
Thank you, ma'am. You can step down. And I would note, just for the record, that Ms. Tremaine was the letter that was filed. And so it's on the Sheriff's Department letterhead, and it was filed, appears to be this morning. And so I will be accepting that as evidence in support of the defense argument. Attached to the letter was the Jail Chemical Addictions Program Certificate of Completion, signed by Ms. Tremaine and dated July 7, 2025. That'll also be accepted as evidence in support of the defense sentencing. Other evidence, Mr. Hoover?
Your Honor, I do want to call Mr. Witt for evidence. He did, it's a little bit different usually. He had a request if he could read his allocution statement first. I don't know if the court is willing to do that, but that was his request that he would like to do.
It's fine with me. I have no issue with that. So Mr. Witt, I've understood you've written down a statement of allocution.
Yes, Your Honor, I've written a letter that I'd like to read to you on my behalf.
Go ahead.
Today I come before you to admit my guilt and the crime I have committed. I'm also here to apologize to you and the state of what I've done. What I'm expressing is a lot deeper than a simple apology. I'm fighting a war with myself that has not only gotten the best of me, but also the best of my peers, fraction of the community I belong to, millions of Americans, and that battle is addiction. Addiction
Yay,
has run my
Kelly,
life and
thank
has hidden
you.
me into lots of negativity, which caused unhealthy relationships with my family and loved ones, and caused me to feel some way about myself that I know is not normal. So instead of sitting idle while in the Marshall County Jail, I decided to put everything in God's hands, stop worrying about things I cannot control, and focusing on the things I can. So I decided to join the JCAP program here at the jail. I learned so much from the program, and I'm so grateful for the tools I've learned. These tools have layered a starting point and will continue to build a path dedicated to my recovery milestone. I take great pride in my participation and even more pride in my graduation. I would like to thank you, Mr. Maine, so much for everything she has done for me. Your Honor, a big part of my recovery is a relapse prevention plan. That's a huge part of my master and exit plan. So I'm asking you for a recommendation in the Recovery While Incarcerated program to help me in this quest for peace and continue this battle. Peace of excuse me, which is addiction.
It gets easier to hear soon.
Your Honor, we have done the RWI program before, but Your Honor, I failed the program because I didn't take the tools from the program and apply those to my life. I got a job when I got out and saved money and got my own place, but I went idle within myself with my recovery. I no longer went to NA meetings, didn't get involved in faith-based programs such as Celebrate Recovery, and I didn't get a sponsor. Your Honor, I didn't have anyone to call if the thought came across my mind to use. The reason I didn't do any of those things listed above when I came home is because I thought I could do it alone. Your Honor, if a trigger turns into a thought and you don't stop it there, it turns into an action step, which is relapse. So what I learned in JCAP and we'll learn in RWI, Your Honor.
This is Indiana, not Elkhart, not. But I can't remember which county it's in. Maybe they'll say it. Maybe when they talk about one of the prisons that he's in, they might say it. And so far, I've only seen this judge here on Court Vibes.
My exit plan will include everything I have talked about, and this time, my knowledge of recovery will be applied to my life. I understand that I will be serving time in prison for the crime I've committed, and again, on the bottom of my heart and soul, I apologize. I'm sorry. I truly believe God will be judging me today, and I'm a firm believer that everything happens for a reason. I beg for mercy from this court, and I pray for
Thank you,
forgiveness.
Bobby. Monroe County.
I want the court to know that when I do return to freedom, I will be a changed man. My testimony will promote hope and strength. Recovery will be a part of my life for the rest of my life. And my mission is to be the best role model for youth and my community, as well as being the best father, grandfather that I can be. Your Honor, thank you for your time. And thank you for listening to my heart. I deeply apologize for what I've done. Thank you, Your Honor.
Thank you, Mr. Witt. And Mr. Hoover, you still have further questions of Mr. Witt in terms of evidence, correct?
Correct.
Mr. Witt, if you can come on up to the witness stand and have a seat. As you have a seat there, sir, I just remind you, I placed you under oath earlier and you remain subject to that oath for these questions.
Yes,
Mr.
Your Honor.
Hoover.
Thank you, Your Honor. Mr. Witt, can you again state your full name for the record?
Johnny Paul Witt Jr.
And how long have you been at the Marshall County Jail at this point?
I believe it's 21 months today.
And you heard a lot of testimony. You were in the courtroom for Ms. Tremaine talking about all the programs you did, correct?
Yes,
And you would agree with all that testimony?
yes, I did everything but art.
Everything but what?
Art, I can't draw,
Oh,
but I
okay.
use my
Um,
time toward everything else.
So, Mr. Witt, when did you start using methamphetamine?
Oh, I guess this was early 80s, I guess. Long time ago.
So you've been using it for most of your life, essentially.
Yeah, using it, then I would try to stop, but like I stated, I try to do it by myself. And I speak for me, an addict will never be able to stop on their own. They need a positive group, just like I have here today. I got
Mr. Witt, you've taken some steps to Marshall County Jail towards your recovery. You're asking for essentially earmark your case for however long incarcerated, is that correct?
Yes, I believe that'd be the next step for me to keep my recovery going and moving forward. Like I said, when I come home, I can apply all that to my life of recovery. Because I want to also be in the Marshall County Hope program. I want to be a recovery coach. Got a lot of years under my belt. I got a lot of things that the youth and children in school. I don't want to see anyone in this place here that's had to live with addiction as long as I have, battling it for many, many years.
I'm sure my question's kind of going that direction. You've been at the Department of Correction before, correct?
Yes,
In fact, you took the recovery while incarcerated program once before, is that also correct?
yes, 2019, I believe is when I took yes.
Okay. So I know the question for the court's going to be if the court gives you recovery while incarcerated again, what's going to be different for you this time as opposed to 2019?
Well, 2019, when I was ready to come home, I had everything in order, preparation. But when I got out, I didn't take the action step. There's 5 stages of change: pre-contemplation, contemplation, preparation, action, and maintenance. When I got out, I didn't follow through with what I knew that I needed. I tried to do it on my own. But this time, like I said, when I'm released, I will have a sponsor. I have a supportive team right here already. I will use everything that I've learned very wisely. I'll have a sponsor to hold me accountable. A network of men that if the thought of using or I need to talk to anyone, I got it there.
I understand that no one has a crystal ball, but you're saying that you anticipate you're going to have those things when you get out this time, correct?
Yes, sir. My sobriety date is January 24th of 2024. That will be my date until the day I die.
The first time you took RWI and you said you didn't follow through, did you not have those things like you do now?
Well, they were available to me. No, not the network of the people that I have here today. That has grown by me proving myself. See, I've let my family down. I've let so many people down that I'm sorry. They're over it. So, but I'm proving myself as I talk to my mothers. I talk to Shayla, as I talk to Amanda, Veronica, because that's my support team. And they're learning to trust me. They're learning to now be open for me. They want to help me. Mr. Maine and Kenny Show, they've all told me that, hey, your support team is here ready for you. I never had that before, but I'll have it this time.
And are there any steps that you plan to take to make sure that you take advantage when you do get out this time around?
Yes, a lot of people when they relapse in addiction is their free time. but I'm gonna keep myself busy. Like I said, I will be a part of the Marshall County HOPE program and hope that they bring me as a recovery coach. I do want to go into the schools and speak to children, the youth groups. And I'll apply everything that I will be refreshed with RWI into my life. But like I said, if the trigger comes, I'm already prepared. I know what I need to do, and I will do it this time. Because Johnny Witt has tried many times on his own. And your own will never work. And like I said, I'm my own worst enemy. I've let myself down so many times. But addiction is a powerful thing. Addiction will either lead you to incarceration or it can lead you to death. Addiction is not a joke. It's true.
Thank you, Mr. Witt. I don't have any other questions.
Mr. Langowski?
Thank you, Your Honor. Mr. Witt, you graduated JCAP on July 7th, 2025, is that correct?
Yes, I did.
You also got into a verbal altercation on July 7th, 2025,
Yes, I did. It was over a game of cards.
in which the jail determined that you were the aggressor, correct?
I do not know that.
You read the PSI, correct?
Yes, I did.
And you saw the jail incident report in that PSI, correct?
Yes,
In which they determined you were the aggressor, correct?
yes,
So the day you graduate JCAP, you get into an altercation, and it's described in there that it looked like you were lunging at the other individual.
I was removed from JCAP program for a verbal altercation. That's what was in there.
That was
I graduated JCAP on July 7th. The only reason that was that far out is Mr. Tremaine was on vacation, or I would have graduated before then.
either way, you still were in JCAP. You're trying to change your life, and you still get into an aggressive situation with another inmate, correct?
Yes, sir, I'm human.
And going through the PSI, going through your criminal history, would you agree that your criminal history spans, in terms of your convictions, approximately 4 decades? The 90s, 2000s, early or 2010s, and now the 2020s?
Yes,
And then with these convictions, these will be your 5th and 6th convictions for dealing some type of substance, correct?
I'm not for sure. I believe some of them that I was charged dealing, but I ended up
Well, you were
pleading
charged,
to possession.
you,
I've been charged with it, yes. But
well, you
what
were
I-
charged and convicted in Arkansas for delivery of marijuana, correct?
Marijuana?
Yes.
No, sir.
Or I'm sorry, a controlled substance.
Delivery?
Yes.
No.
Manufacture, delivery, possession.
Possession.
Okay. And then here in Indiana, you had the A felony or for methamphetamine in Stark County, correct? Or is it a B felony?
You don't know which one? It's B felony. It's a B felony.
It's a B felony for methamphetamine. And then here in Marshall County, a level 4 felony, correct?
Possession, I believe, yes.
Dealing.
Oh, okay. Yeah.
And then you were modified on that, correct?
Yes, sir.
And then you violated that probation, correct?
In Marshall County, no.
So the PSI is incorrect?
I completed probation in Marshall County. I did not complete it in Stark County.
And then you went through RWI before, correct?
Yes,
And did you successfully complete that in that first time in RWI?
yes, I did.
But then you got out and went right back to doing what you were doing, correct?
No, I got out in 2021. I caught this charge in 2024.
And
No,
the-
I was 2 years plus in the street doing the right thing. I had a job at a union shop. I have my own place.
when was your release date in 2021?
October.
And so almost 2 years to the
Yes.
date in 2023, you were dealing again.
I relapsed in my recovery. Yes,
I mean, these weren't small amounts of weight, correct?
no, sir.
An ounce of methamphetamine is pretty significant given the drug, correct?
Depends on what you're comparing it to. I don't know what you're trying to say about the.
I mean, it's not, it's, it's different than an ounce of marijuana, correct?
Well, they're both ounces, but they're separate things. Yes,
And you would agree methamphetamine is a more dangerous drug.
I didn't do marijuana. I don't know. I really can't answer something I don't know anything about.
Bullshit. Bullshit, sir. Bullshit.
I have no other questions.
Redirect on that, Mr. Hoover?
Just briefly, Your Honor. Mr. Witt, we had reviewed the incident reports that were made with the jail, correct?
He really just said he doesn't know if meth is worse than marijuana? Is that what he said?
Yes,
It looked like there were two for behavior and then one was for information. You recall that?
yes,
The two that were for behavior, were those both regarding arguments over card games?
I believe so.
Okay. Was there any type of physical altercation during either one of those?
No, it's verbal altercation. I'd like to speak on the one in 30 pod in the JCAP program. The reason why I was removed for the verbal altercation is because Mr. Maine was going to make me a mentor, and I was unable to follow through with what was required of me to be a leader in the program, so I was removed. And I understand why that was done. And the other one, I said, is argument over a game of cards, no physical altercation at all. And then the third one was I was a cook in the kitchen, and a cookie got sent out to a diabetic tray. So I was terminated from the kitchen for that.
So you were a trustee at that time?
Yes, I've been a trustee about 3 times since I've been at the jail. They've always given me a chance, and after things cleared up.
And so you think that was the information?
Yes,
I guess, write-up, we'll call it.
right up, right.
Okay. You think that this cookie being served to a diabetic person was the information, right?
Yes, it was.
Nothing.
You cross on that, Mr. Langowski?
Just give me 1 second, Your Honor. No, Your Honor.
Mr. Witt, I'm a little confused on this incident report that led to your removal from JCAP. You indicated that Ms. Tremaine was going to make you a mentor and that you denied that or otherwise couldn't meet the achievements, so then you were removed. And this is my confusion. I heard Ms. Tremaine testify that there was some disrespect and she was not going to tolerate that, so you were removed. So I'm left with trying to reconcile that testimony with what you just said. So please explain that further to me so I can understand.
I think Mr. Maine meant as disrespect toward another fellow person in the program, because that's what it was. Is I got into a verbal argument with a gentleman over a game of cards. And once you complete the program, Mr. Maine, either she removes you to let someone else come in, or if she sees that you're a leader in the program, she will ask you to be a mentor. And like I said, I was going to be a mentor of the program, but I was removed because that I wasn't leading by example, Your Honor. I didn't lead by example in that.
Mr. Witt, who's in the courtroom here today? Multiple times during your testimony, your statement of allocution, each time you referenced your support system, and it seems as though specifically perhaps your children or younger individuals than you you've gotten choked up and emotional. So please identify who's in the courtroom as your support system.
My sister Kay, Veronica, my two daughters, Jessica, Amanda, my mother, my brother-in-law, my friend, and my fiance. Your Honor, the reason I got choked up is Jessica Taylor right there, that's my oldest daughter. We haven't spoken in a long time, Your Honor. Because my daughter's tired of hearing, Dad's sorry, or Dad relapsed again. She's sick and tired of my addiction. And I never expected to see her here today. Your Honor, everybody that's here is I never expected to for this much support because I've been battling my addiction for so many years, Your Honor. I'm 55 years old, Your Honor. I've got grandchildren out there. I've got my kids I need to be there too. Like I said, I apologize from the bottom of my heart. But I have to take responsibility for what I did, Your Honor. I'm my own worst enemy. They forgive me, but I still struggle with it, but I try every day. You'll be able to get up and look at myself and say, hey, you can do this, Johnny. If you decide to do it, you can do it. Because once you do everything, you'll have the tools to do it. You got the support team that'll be there for you. So with God on my side and me putting everything I have into it, Your Honor, on my recovery, I'm going to be okay. I'll be okay.
Thank you, Mr. Wood.
Thank you.
Did that raise questions, Mr. Hoover?
No, Your Honor. Thank you.
Mr. Langowski, did that raise questions?
Just briefly, in terms of when you were removed from the JCAP program, when were you removed for the disrespectful behavior? Is that in 2024 or 2025?
It was this 25 when I completed the program. It was
And
August 7th.
you heard Ms. Tremaine's testimony, correct? Have you seen the letter she's written?
Yes,
And did you see in there where it says that you were terminated from the program on August 18th, 2024 due to behavior reports from the jail regarding disrespectful behavior?
I wasn't in the program at that time. And what the incident that you're speaking on?
The
I was
August 2024.
yes,
Okay.
I was a trustee, but when you're a trustee, you're also a part of, that's automatic that you're part of the JCAP program. I didn't live in 30 Pot, I was a trustee.
Okay.
So like I said, even though when I got terminated for the cookie incident, I was removed from the JCAP program also.
Okay.
So that shows another time, an incident that I'm removed from the program. It was
Okay.
nothing to do with.
So that's where the cookie incident comes from.
Yes,
Okay. And then fast forward to July of 2025, that's when the argument over the card games happened that caused that removal.
yes.
Okay. I have no other questions.
Mr.
No
Hoover? Thank you, Mr. Witt. You can step down. Watch your step there.
Thank you, Your Honor.
While Mr. Witt makes his way back to the chair, is there any other evidence you're anticipating submitting?
No, Your Honor.
We shall close the defense evidence here. Moving into the argument phase here, Mr. Langowski, what's the state's argument here?
Thank you, Your Honor. Your Honor, this plea calls for a 17.5-year cap on each level 2 felony with your decision to run them either consecutive or concurrent. I'm going to start with what the state's asking. The state's asking for a 32-year sentence. We believe under Indiana Code 3551-2, this court can run these sentences consecutive, but there would be a maximum penalty of 32 years. We base that on the fact that we don't believe this to be a single episode of criminal conduct. These are two separate deals, 2 weeks apart. Yes, they are to the same person, but they're two separate transactions, each involving a different ounce of methamphetamine. However, if the court believes that this to be a single episode of conduct, the court still has the discretion to run these sentences consecutive based on the aggravating circumstances. So when we get to the aggravating circumstances, the large glaring one is his criminal history. It spans 4 decades. He's been to prison before. There's multiple dealing convictions. These are 2 additional dealing convictions. He's been on probation before. He's violated probation before. He completed substance abuse program, mainly the RWI program, and still repeated the same behavior. The least restrictive means have been tried and failed numerous times. And I would note that the criminal history is in 2 separate states. In terms of mitigators, we see is that he's pleading guilty, he's accepting responsibility, and that it seems at this point he is taking things a little bit more seriously. However, at some point in someone's criminal history, they're no longer an addict and they are a drug dealer. Mr. Witt says that this is all based on his addiction, but the 2 deals here are significant amounts of weight. It's an ounce of methamphetamine, a very dangerous drug. He's been previously convicted of dealing methamphetamine in this county before. So at some point, as you continue that behavior, it's not an addiction issue. It's a dealing issue. So that's why we're asking for a 32-year sentence, 17 and a half years on one of the level 2 felonies. And then I believe the math would be 14 and a half years on another to run consecutive to each other to make it for 72 years or 32 years. And then we will leave RWI to your discretion. Thank you.
Mr. Hoover, defense
Thank you.
argument.
Your Honor, first off, one thing that can be argued is obviously Mr. Witt's criminal history is, for lack of a better word, is terrible. I think that he'd be the first one to acknowledge that. You heard his testimony. He's been using methamphetamine since the 80s. So this is nothing new for him, unfortunately. It's something that he's battled his entire life. And frankly, he's probably going to continue to battle his entire life. I think that he acknowledged that he's going to need a lot of safeguards in place to control that when he does get out, whenever that is. So that obviously is a major aggravating circumstance. I think the main thing here is whether or not these are run concurrently versus consecutively. And I do agree with Mr. Langowski that I do think that is discretionary for the court. However, I think in this instance, concurrent is much more appropriate. Your Honor, the deals are the same person. I believe it's doing a CI in both instances. It's 2 weeks apart. This would be the kind of case you normally see under one cause under 2 separate counts. So I believe it's more appropriate that they are run concurrently in this instance. I think given that circumstance, I do believe that probably the maximum that the court can do, the 17 and a half years, is probably appropriate on each one of the causes, but they are run concurrently. As far as all the other terms, Your Honor,
Hi, Malta.
I'd ask that you give him a federal incarcerated while acknowledging the fact that he has done it before. So I understand the court may be a little wary to let him out under the same circumstances that a lot of people would get. He has done it before. He did relapse after doing it the first time. But I would ask that he be given that treatment again. I don't think that harms anyone by letting him continue treatment while he is at the DOC. So I would ask that. Your Honor, I guess just one comment on Mr. Langowski's, dichotomy here. A lot of our clients who are addicts end up as dealers. I mean, this is kind of what happens in the situation. It does not excuse the behavior. Obviously,
that is only fueling the problem in our community. And I think that Mr. Wood would acknowledge that 100%. At the same time, at the end of the day, he is an addict. He's battling this. He needs treatment. So I am asking that the court give him RWI, run these concurrently. I think that's supported by the case law. There's been some 7B appeals that have been granted. The sentence has been revised to run them concurrently in this kind of instance where you have these deals that happen very close in time, a couple weeks apart, just like this one. So I am asking that concurrently, 17 and a half years on both, but you know, thank you.
Thank you, Mr. Hoover. Any follow-up from the state?
Again, I think even based on the aggravating circumstances that these should be run consecutive to each other, and the court has that discretion absent this being, if the court finds this a single episode of conduct. That's it, Your Honor.
And you're referencing the single episode of criminal conduct under the sentencing statute where it caps what the maximum sentence can be. Correct. That's why you're arguing for 32 years as compared to 35 years, with 17 and a half being the cap on each.
Correct.
Well, Mr. Witt, I would note for you, this is typically when I would turn to you to say, if you have a statement of allocution. You've already offered that statement of allocution. I do want to turn to you for just a moment to say, is there anything else you want me to know at this juncture? You've already given me verbally your statement of allocution, but I do want to give you this opportunity, if you so choose, understanding you previously provided that.
Nothing else, Your Honor.
Thank you, Mr. Witt.
Thank you.
In review of the PSI and written report, there were a couple of things that were very glaring to me, and we discussed them here. Mr. Witt's acknowledged them. Mr. Hoover's argued and acknowledged them, but the criminal history in this case is overwhelming as it relates to the level of offenses and the types of
Thank you,
offenses.
Martha. Thank you.
Given that this is a dealing offense, it is one of the worst criminal histories that I have reviewed. It is not the most extensive that I've reviewed, but the level of offenses is what I'm pointing to. There's that B felony that was referenced, and then there's various other dealing offenses that are all higher level felonies, as compared to trivial, small misdemeanor offenses habitually occurring here. And so it's overwhelming, the criminal history. Additionally, within that criminal history, there's violations of probation. There was I would say at this point, alleged violation of a modified sentence, in the sense that in the Stark County case of 75 C01 1712 F410, there was a dealing in methamphetamine conviction entered, and then there was a modified sentence entered in 2021, and then there was a violation of the probation that was imposed, filed. Now that violation has not been adjudicated because there's a warrant outstanding from what the PSI indicates, and so it's alleged that you violated the terms of the modified sentence. But there are other prior violations of probation that have been adjudicated and found. Additionally, and I don't want to go too far into this, but I think it's self-explanatory that there is some disciplinary conduct at the jail. I recognize kind of the explanatory circumstances of how things occur, but the bottom line is there is more than one disciplinary incident at the jail. Mr. Witt acknowledged those, talked about those, largely understood them, however, had kind of a different view, which I would understand given his circumstances. I would also note, as the PSI indicates, there is a conviction, and it's not clear exactly what it's for, but it is for manufacturing, possessing, or dealing in a controlled substance out of Arkansas. And so, again, it's in that dealing line. Regardless of whether there is a modification violation or not, I think it's unequivocal that at the time of committing these two offenses, you were on probation for being supervised in that Stark County. Case, and so therefore that's another aggravating circumstance. Mitigating
Oh, I
circumstances
did the
that I
wrong
see
one.
is that you pled guilty today.
I was saying that looks
Acknowledge-
big. That looks big, I think. I don't want to make it bigger, bigger, bigger. Alright. Well, if I make it bigger, that's good. That you know how long it took me to figure that stuff out.
responsibility for your role in these crimes, and so you receive that weight. You've also done so without having set term plea. I would say there is some hesitance in my mind to give the full weight because there's an agreed upon cap, and so you did not do so with the full weight of what would be the up to 30 years on each conviction. So you get some benefit from the plea agreement. Now, I do want to note one thing about the facts and circumstances of the case, and this is getting into the decision about consecutive or concurrent nature. In the PSI and written report, I noted that Mr. Witt stated that he would typically use, and this is on page 12 of 14, indicates that he would use about a half of a gram at a time. And the reason I point that out is there was considerable back and forth about the weight of the drug, an ounce, 28 grams, etc. And the reason I point that out is, at least in the PSI, Mr. Witt made acknowledgement that he used half a gram. This is the specific point. I recognize that addicts often become dealers. And I don't see it as the state does, that it's mutually exclusive. But where I go to that is that if the addict is using a half a gram, the addict knows how much an ounce will allow the other addict to use. So if a half a gram is good for you, Mr. Witt, an ounce is going to be double because it's 28 grams times 2 of use. And so the reason I point that out is I understand what the state was getting to with the line of serious or substantial or a higher amount of weight. And the reason I say this is it's apparent to me that when these deals were occurring, you would have known that amount. You would have known how much that would have been able to be used, meaning it wasn't simply a one-use deal. By definition of your use, it would have been multiple uses for that individual. So I think that's relevant to the consecutive or concurrent nature of the sentence. Ultimately, given what I have seen in the PSI and written report, I'm convinced that the sentences should be imposed consecutively. The question becomes what the number of the years is. And I struggle with these because, Mr. Witt, you may have heard and you may know that I supervise the drug court, and I'm very sympathetic to individuals in addiction. But what I can't understand and can't follow is how the habitual nature of the dealing occurs. I recognize that addiction is a genuine disease and a genuine plague on someone's personal behavior. But the ounce and the 28 grams is where I then go to in my mind to say that is far beyond personal use. I don't agree with the state that the full 32 years should be imposed. What I think is appropriate here, given the criminal history, given the violations, given the aggravators and mitigators, is a slightly lesser sentence. What I think should be imposed is the 12 years on each of the counts and run those consecutive. That gives some credit for the mitigating circumstances that I've found, but also, as I've indicated, I believe consecutive sentences are appropriate given the facts and circumstances and the aggravators and mitigators. So it is not the substantial sentence the state's asking for, but it is not in agreement with Mr. Hoover either. So, Mr. Witt, ultimately, that's what I arrive on, is that 12 years is the appropriate number for each of those convictions, given those aggravators and mitigators. I would note that that's only 2 years above the minimum for each, but I recognize this is an executed sentence at the Department of Corrections, and so I'm imposing it knowing that, yes, it's close to the minimum for each count, but it is an executed sentence, and I will not
I
be
missed
suspending any
it.
of
What was it?
given the prior violations of the community corrections. I'm simply going to impose the dollar fine on each of the counts and the court costs, but I am going to note that you do not have the ability to pay those, and I'll be waiving those fines and costs as well. Questions over the court sentence, Mr. Lankowski?
Yes, Your Honor. That is also to be consecutive to any sentence on that Stark County case, correct?
Correct, yes. I think that's statutorily required that I have that. Mr. Hoover, questions over the court sentence? No,
What
Your
was the sentence?
Mr.
I
Witt, you have
missed
questions
it.
over the court sentence.
No, Your Honor.
I'm going to remand you back to the custody of the sheriff. Mr. Hooper, as he goes back into the holding cell, can you approach with Mr. Langowski for a minute?
12 years on both counts, or 24 years. Concurrent. Okay, I've decided what I'm going to do now with this Victoria case. I am going to move on to Australia. I am. It is it's sad. It's a little sad. And outstandingly hard to listen to in the middle because it's a little boring. So what I'm going to do is I'm going to play the first part until my mind starts wandering and I can't take it anymore, and then I'm going to fast forward it to the end. And then you won't miss much, I promise. I promise. I don't know. Maybe if chat distracts me, I'll forget all about the court case. And it'll just play on and play on. That happens quite often. The accent is outstanding. That's all I can say. The accent on this one is outstanding.
Connor Matheson, you have pleaded guilty before me to one charge of culpable driving causing the death of Elise Hodder and one charge of negligently causing serious injury to Emma Sword.
Ugh, that sucks. Do we want to talk for like 3 minutes? 2 minutes? Well, I bump up this volume real quick, or should I just press play as I'm bumping up this volume real quick because I can't hear it? This should only actually take less than 1 minute. This should only take a few seconds, and it'll be worth it because this one is hard enough. We are less than 60 seconds away. I think. Almost. We're at 67%. 73. 85. Bump up the volume, dance, dance. 97, 99, done. When I just went to start this, I saw that I had already did this and had a different clip ready with the volume up. It's fine.
Connor Matheson, you have pleaded guilty before me to one charge of culpable driving causing the death of Elise Hodder and one charge of negligently causing serious injury to Emma Swords. You may be seated for now. The maximum penalty for culpable driving is 20 years imprisonment, and the maximum penalty for negligently causing serious injury is 10 years imprisonment. Culpable driving has a standard sentence of 8 years, the meaning of which I will return to. The circumstances of your offending were comprehensively outlined in the summary of prosecution opening dated the 15th of October 2025. I have also viewed CCTV and body-worn camera footage of the incident and the aftermath. I will summarise the circumstances here. On the night of 12 October 2024, you went to a rave near the Sir Zelman Cowan car park at 458 Kooyong Road, Kooyong, with your friends Soda Pop White, Aidan Creevy and Joshua Creevy. You were not licensed to drive, your licence having expired on the 9th of July 2023. You had driven your friends in your gold Holden Commodore sedan from Sunbury to the rave, leaving at about 10:30 p.m. and arriving between 11:30 and midnight. You and your friends shared a 10-pack of pre-mixed Jack Daniels and Coke cans during the drive. You continued to drink at the rave, At about 1 a.m, your group decided to leave the rave and all got into your car with you driving. Miss White was in the front passenger seat and the Creevy brothers were in the back. At the same time, Elise Hodder and her friends Emma Swords, Hugh, Jeremy Orr, Olivia Fahey and Beau arrived at the Sir Zelman Cowan car park. They got out of the car and walked through the car park. Coincidentally, a marked police vehicle was present in the car park at this time. Officers Nagao and Clinton commenced their body-worn camera footage at 1:07 a.m. on the 13th of October 2024, meaning that the incident before the court occurred at 1:06 a.m. Senior Constable Nagao described what happened as follows. Out of the corner of my right eye, I saw a vehicle drive north in the car park approximately 25 metres in front of me at an extremely fast rate of speed. I'd say 60 kilometres an hour or something.
That would be very hard for me to believe. Because the way they describe it is this car backs up out of the car park and hits a couple cars and then turns and hits these people. So it would be very hard to believe that they were going that fast just out of a turn. But I wasn't there.
The vehicle was a gold-coloured sedan and drove straight into a group of pedestrians in the car park to the left-hand side of us. From what I remember, it was the front of the car which impacted the group of pedestrians. I saw one person go under the engine block area of the vehicle, get dragged under. The vehicle went backwards a bit, then accelerated forwards again over the pedestrian and into a white wagon which was parked. Hitting the parked vehicle prevented the gold-coloured sedan from going further forward. The police officers moved their vehicle to block your car in. Senior Constable Nagao removed you from the vehicle and arrested you. Elise Hodder was trapped beneath your vehicle. Emma Swords was hit by your vehicle and was seriously injured. Jeremy Orr was knocked to the ground by your vehicle. Senior Constable Nagao asked why you had driven over the pedestrians and you said, "I'm so sorry, I didn't mean it, I didn't mean it, I didn't mean it." You were handcuffed while the officers attended to your victims. Senior Constable Nagao went to Miss Hodder and tried to comfort her. He did so for some 5 minutes until she lost consciousness and stopped breathing. It was later determined that Miss Hodder died from chest injuries and mechanical traumatic asphyxia. Miss Swords suffered 2 badly broken ankles which were repaired during several surgeries using pins and plates. She was wheelchair bound for some 10 weeks and had to learn to walk again. Mr. Orr sustained minor rib and knee injuries. A preliminary breath test revealed your alcohol concentration to be 0.177%. A later blood sample revealed a blood alcohol concentration of 0.213%. Your blood further contained metabolites of cocaine and cannabis. However, it cannot be determined when you took these substances, so they are referred to as context only, not one of the bases of your culpability. Investigations conducted by leading Senior Constable Timothy Bale, an accident reconstructionist, determined that your vehicle had been parked nose in, facing south, to a parking bay in the car park. You reversed out and made a left steering input, resulting in the front of the vehicle rotating clockwise. Your car impacted the rear of a Nissan vehicle before colliding with the pedestrians. The driver's side of your car impacted with the rear of a Haval vehicle. The pedestrians were hit and the Haval was rotated anti-clockwise. Your brakes were not applied at the time of impact. Your vehicle continued to rotate until it was facing north, approximately 180 degrees from its initial position. You then drove forward over Miss Hodder and colliding with Miss Swords and Mr. Orr. You continued accelerating, pushing the Haval approximately 90 degrees until it mounted the gutter. You have pleaded guilty to culpable driving on the basis that you were under the influence of alcohol to such an extent as to be incapable of having proper control of a motor vehicle, your blood alcohol concentration being between 0.177% and 0.213%, and on the basis of negligence. The negligence being that you A, were under the influence of alcohol, B, failed to keep a proper lookout while reversing, C, reversed at speed in a car park open to the public, D, impacted two vehicles that were parked behind your vehicle. E, impacted a group of pedestrians who were walking in the vicinity of your vehicle. F, failed to immediately stop the vehicle on impact with the vehicles and pedestrians. G, failed to keep a proper lookout while driving forward after the initial collisions. H, drove forward at a speed in a car park open to the public. And I, again impacted one of the two vehicles and the group of pedestrians. You have pleaded guilty to negligence causing serious injury to Miss Swords on the same basis of negligence. For context, you were caught by a speed camera on your way to the rave driving in excess of the speed limit. You were unlicensed. You were drinking while driving. You had metabolites of cocaine and cannabis in your system. While not part of the charges before the court, all of these factors demonstrate your contempt for the safety of the other road users on the night in question. The objective gravity of the offending before the court could not be higher. Miss Hodder has lost her life. Miss Swords' future has been irreparably damaged. All those who know and love them have been impacted and will continue to be so, all because you chose to drive negligently while significantly affected by alcohol. It has been suggested that someone in the car yelled "go forward" after the initial striking of the pedestrians. This may well have been the case, however you were the driver and responsible for paying proper attention to your surrounds. It is in no way mitigatory, but perhaps reflects an element of panic in the moments after the offending took place. You assert through your counsel that you intended to leave the car in Melbourne. I find this an unlikely proposition, but not one with any bearing on the outcome of the case. The fact is, you did drive the car after the rave, and you did hit Miss Hodder and Miss Swords. You will have to live with that decision for the rest of your life. Your blood alcohol was between 3 and 4 times the legal limit. Your driving was erratic, and while of short duration, was fast and dangerous and placed 3 people in direct risk of harm, a risk that was so tragically realised. Taking into account your voluntary substance use, the nature and extent of the injuries inflicted on your victims, the number of people put at risk by your driving, and the nature of the driving itself, I find your moral culpability to be very high. I received 25 victim impact statements in this matter, 13 of which were read to the court. All very eloquently detailed the impact of your offending on Miss Hodder's family and friends, and on Miss Swords and her family and friends. You have taken the life of one much loved young woman and seriously injured another. The grief you have caused is immeasurable. Michael Hodder, Miss Hodder's father, told the court of the depth of his loss and the devastation of losing his daughter. His heart and soul have been torn apart. He stated, "There is not healing. The wound remains open. I grieve daily while trying to support her mum, her brothers, their partners and their daughters. Elise's death should never have happened. Our lives are forever changed and Elise has none." As Mr. Hodder said, no family should ever have to bury their child in such cruel and evil circumstances. Pauline Courtney, Miss Hodder's mother, told the court that the loss of Elise in such sudden and horrific circumstances has been utterly devastating. The experience of being woken at 6 a.m. by 2 police officers at our door and being told that Elise had been killed by a drunk driver was beyond traumatic. There are no words to describe that level of shock and disbelief. The thought of that being the end of her life and in those circumstances, without me or Michael there to comfort her, is unbearable. As her parents, we had always protected her and kept her safe. I would have lain beside her, kept her warm, kissed her, comforted her, and told her that we loved her. I would have said goodbye. What a violent, cruel ending for my gentle, loving girl. Miss Hodder's parents were required to identify her, but due to the extent of her injuries, much of her body had to remain covered. This caused them further profound sadness, as has the loss of future milestones and achievements. As Miss Courtney stated, the emotional impact of Elise's death has been catastrophic. Emma Swords detailed the guilt she suffers for having survived the collision and how she recalls images of her friend dying beside her. She also outlined the horrific injuries she suffered as a result of your driving. The multiple operations, the metal fixation and casts on her ankles for months.
especially since CJ said, wait till you hear the sentence. They are legislated and nothing like we see here in the United States. If they plead guilty, they get credit for that. They get years off their sentence for pleading guilty because they don't put the courts through the money and the time and everything it takes to litigate, to go to trial. So if you plead guilty, you get years off. Like, I think in the UK, I think it's 25% for a guilty plea. You get 25%. So whatever the sentence is, they say you get 10 years, and then they say, okay, and now you get 25% off of that.
She has lost her job, her apartment, her friends, and her independence, having had to return to her family interstate. She stated, "I will never be the person I was before that night. I will carry this loss, this grief, and this fear into everything I do. I saw my best friend die. I survived in a way that haunts me." Friends and relatives of Ms. Hodder variously described feeling her loss as a constant weight of sadness, anger, and helplessness, a roller coaster, complete emptiness, suffocating in grief, and like drowning. Friends and relatives of Ms. Swords note her mental and physical suffering and her withdrawal from them because of the fear and trauma she now carries. While I have only quoted from several of them, I take the contents of each victim impact statement into account and recognise the catastrophic impact of this offending. These statements are an important factor in the sentencing synthesis. However, I must take care not to let the consequences of your offending overwhelm the sentencing considerations. You offered to plead guilty to the offending in July 2025. Your counsel submitted that you were always going to plead guilty, but that was not clear until after your receipt of the statement of Dr. Schreiber, you having previously offered to plead to a lesser alternative. I accept that after the additional statement was served, you indicated a plea and entered pleas to the current indictment. While I do not find your plea was entered at the earliest stage, no witnesses were cross-examined. Your plea has significant utilitarian benefit in that you have saved the court and the community the time and expense of running a trial, and most importantly, spared the witnesses the ordeal of giving evidence. In those circumstances, you have facilitated the administration of justice, and you are entitled to a benefit for that. By your plea of guilty, you have accepted responsibility for your offending and demonstrated ongoing remorse. You made immediate expressions of remorse at the scene and were appropriately distressed upon hearing the victim impact statements. You told Mr. Newton that you still think about the accident and its effects, maybe twice a day, thinking about how it affected people and how it would still be affecting them. I know how it feels to lose someone abruptly, and that fact, that I'm the one who made the decision that caused it to happen to them, is really hurtful, but prison is more on my mind. It's hard not to think about prison all the time. I'm worried about the victim and the victim's friends, and I have written letters to them, but I'm not sure about sending them. It was pretty difficult. They just seemed to want me dead. I would probably want the same thing. You are clearly immature, as reflected in your statement that prison is on your mind, while others are so clearly suffering as a result of your actions. While you have displayed a concern for your own welfare, I find that this coexists with your remorse. I turn now to your personal circumstances. You are now 24 years old, having been born in February 2001. You were 23 at the time of the collision. You have an older brother and a younger paternal half-brother. You were initially raised in Riddles Creek, but your mother, who suffered from schizophrenia, bipolar and severe postnatal depression, found the location isolating, and your family moved to Sunbury when you were about 6. Your father was a senior executive and was often interstate or overseas for work. Your parents protected you and your brother from your mother's mental illness as best they could, but your early years were turbulent. Your mother was often hospitalised, and visiting her was a regular weekend activity for your family. Your parents separated when you were aged 12, and after living with your mother for a brief period, you moved to live with your father. Your father commenced a new relationship when you were about 15 years of age, and after some initial difficulties, you now get on well with his new partner. In 2017, when you were 16 years of age, your mother took her own life. According to Patrick Newton, whose report I shall return to, you experienced a complicated grief response incorporating strong feelings of loss together with intensely ambivalent feelings regarding the circumstances of her death and the illness that had preceded it. You did not receive any psychological treatment at this time. You attended local schools before attending Collingwood College for a brief period. You completed Year 10 before leaving formal education. You have worked in a range of unskilled positions, including assisting with carpentry, plastering and cabinet making. Your employment has been interrupted by your substance use. Since this incident, you worked casually at a fish and chip shop, but this employment petered out. Your cannabis use commenced in high school and you were using at the time of your mother's death. Your use escalated thereafter. You drank in your teenage years, but did so heavily from the age of 17. It was at this time you also began to use party drugs such as MDMA and stimulants, and on occasion hallucinogens. Following the collision, you continued to use cannabis for several months, but have now ceased its use. You have not been intoxicated since the collision. You were involved in a serious relationship for about 2 years in the period leading up to the collision, but it suffered due to your heavy substance use. While the relationship had an on-off phase, it ultimately concluded a couple of weeks before the collision. I received a report and an addendum report from clinical and forensic psychologist Patrick Newton, dated the 15th of October 2025 and the 21st of October 2025 respectively. He diagnosed you with severe substance use disorder in remission, post-traumatic stress disorder in partial remission, and mild to moderate major depressive disorder. Mr. Newton opined that it was the substance use which had the most significant impact on your offending, as the PTSD was precipitated by the collision and the depressive disorder only reached diagnosable significance as a result of the collision. These effects, being your offending, were the result of self-induced extreme consumption of alcohol and other drugs which took place on a voluntary basis and with full awareness of the likely effects it would induce and the risks this posed. That is, the drug and alcohol use which you voluntarily engaged in was the cause of this collision. While you would have been behaviourally disinhibited, had difficulties exercising appropriate judgment and making reasoned decisions, as a long-time drug and alcohol user, you well knew that these were the consequences of your substance use, yet you chose to drive. Mr. Newton further opined that your offending took place in the context of your immaturity. Your immaturity did not cause the collision, but it is something that needs to be addressed in your rehabilitation, a factor to which I will return. Being immature, your moral reasoning is prone to be pragmatic and self-focused. Mr. Matheson, this was a catastrophic collision entirely of your own doing. You chose to drink to excess and then to drive. You were a collision waiting to happen, and there is now no undoing the consequences of your overwhelmingly negligent behaviour. At 23 years of age at the time of the offending and 24 now, you are not a young offender, but you are still youthful. I must therefore give weight to your rehabilitation as per the principles in the Queen and Mills and as a party in the Queen. In the Director of Public Prosecutions in Hill, however, the Court of Appeal stated at 50 that while rehabilitation of a young offender is a very important consideration in sentencing, the authorities demonstrate that it must sometimes give way to other sentencing considerations, particularly general deterrence and denunciation. That is so here, and despite your age and immaturity, which I do take into account, general deterrence must play a significant role in the sentencing exercise, given the overrepresentation of young men in culpable driving cases before the court. Unfortunately, the offence of culpable driving is one which is frequently committed by young drivers. If general deterrence is to be meaningful, it must be directed towards this class of offenders and cannot be regarded as irrelevant because of their youth. Just punishment and denunciation are also important factors given the loss of life and serious injury resulting from your offending. As submitted by your counsel, specific deterrence has less of a role to play in the sentencing exercise than general deterrence, although I disagree with the proposition that it has no work to do. You have one irrelevant prior matter and have had 2 speeding infringements, but the impact of your imprisonment is likely to be salutary. I take your previous good character into account. When released on bail, you complied with the Court Integrated Services Program and underwent alcohol and other drug counselling and psychological counselling. You were exited from KISP upon successful completion of these treatment programs. In light of this, I consider your prospects of rehabilitation to be good, dependent on you engaging with further drug and alcohol treatment and further psychological counselling. You are immature, but will spend a considerable period of time in custody in which you can undertake rehabilitative programs. Similarly, I consider community protection to be a reduced consideration if you engage with treatment. Should you do so, I consider you are unlikely to reoffend in this way. Your family are a pro-social influence on you and have and will no doubt continue to support you upon your release. It was submitted on your behalf that limbs 5 and 6 of the Queen and Verdens have application in your case. That is, a term of imprisonment would weigh more heavily on you than on a person in normal health, and that there is a serious risk of imprisonment having an adverse effect on your mental health. Based on the report of Mr. Newton, I find that your post-traumatic stress disorder in partial remission and mild to moderate major depressive disorder call for a modest reduction in sentence pursuant to Limb 5 of Verdens. I am not, however, persuaded that Limb 6 has application. Mr. Newton opined that, in a custodial context, your youth and immaturity, your vulnerability to negative influence, your status as a first-time prisoner, and your pre-existing emotional distress would all pose challenges. It would be likely that you would require a greater level of support as a result of such factors. That a greater level of support is required is not an indication that your psychological conditions will deteriorate in custody, rather that you should be monitored and helped to adjust. While not applying Verdens Limb 6, I nevertheless take these factors into account generally. The standard sentencing regime applies to charge 1 with a standard sentence of 8 years. The standard sentence for an offence is a sentence that, taking into account only the objective factors affecting the relative seriousness of that offence, is in the middle range of seriousness. I must take the standard sentence into account as one of the factors relevant to sentencing. This requirement is to be treated as a legislative guidepost having the same function as the maximum penalty. It does not affect the established instinctive synthesis to sentencing or require or permit two-stage sentencing. The court must only have regard to sentences imposed in cases where the standard sentencing regime applies. I have taken the standard sentence for culpable driving into account as one of the factors to consider in my instinctive synthesis of all the relevant factors in your case. Further, where a court is sentencing an offender in respect of 2 or more offences, one of which is a standard sentence, the court must fix a non-parole period of 60% of the relevant term where the relevant term is less than 20 years. Must fix a non-parole period of not less than 60% of the relevant term where the relevant term is less than 20 years. Culpable driving is also a Category 2 offence, meaning I must not impose a term of imprisonment in combination with a community corrections order unless one of the exceptions in 5(2)(h) of the Sentencing Act is met. No such exceptions were argued here. I further apply the principle of totality, noting that the offending in each charge arises from the one incident. I must recognise the fact that there are 2 victims of your offending, but I moderate the accumulation so as to impose a sentence that is proportionate to your overall conduct. Both parties submitted that the only available sentence is one comprising of a head sentence and non-parole period. Mr. Hutton SC for the prosecution took me to several cases, namely Rakatau and the Queen, Victorson and the Queen, Fong Tai Hong and the Queen, and DPP and Reed. All involved pleas of guilty to culpable driving. Rakatau and Victorson each involved 2 deaths. All involved other offences. Total effective sentences imposed ranged between 10 and 13 years. Mr. Nathwani KC, appearing for you, took me to the DPP and Reed and DPP and Aegis. Reed involved a plea to culpable driving and other offences, and Aegis was a sentence imposed after a trial which involved culpable driving and negligently causing serious injury, resulting in a total effective sentence of 9 years and 8 months imprisonment. I take each of the cases to which I was referred into account by way of current sentencing practices insofar as they are relevant to the instant matter. Finally, I remind everyone in court that the sentence I am about to impose is not and is no way intended to be a reflection of the value of Miss Hodder's life. No sentence this court can impose can in any way compensate for her loss. This is a sentence based in law, applying the principles of sentencing that I must take into account. Mr. Matheson, would you please stand? On charge 1, culpable driving, you are sentenced to 8 years and 9 months imprisonment. On charge 2, negligently causing serious injury, you are sentenced to 4 years imprisonment. Charge 1 will be the base sentence. I direct that 2 years and 3 months of the sentence imposed on charge 2 be served cumulatively on the sentence imposed on charge 1. That makes a total effective sentence of 11 years imprisonment. I direct that you serve a minimum non-parole period of 7 years before being eligible for release on parole. I declare that pursuant to Section 18 of the Sentencing Act 1991, you have served 18 days by way of pre-sentence detention. I declare that pursuant to Section 89(1) of the Sentencing Act 1991, your licence is cancelled and disqualified for 9 years from today's date. Pursuant to Section 89(c)(1) of the Sentencing Act 1991, I make a finding that the offence was committed while you were under the influence of alcohol, which contributed to the offence. This is to be noted on the record. I declare that pursuant to Section 6AAA of the Sentencing Act 1991, had you not pleaded guilty to the offences before the court, the sentence I would have imposed would have been a total effective sentence of 13 years and 6 months with a non-parole period of 9 years. You may be seated.
We made it through. I didn't even bump it ahead. I just played the whole thing. So, yeah. I mean, it's not 3 years. He's going to be a decade older by the time he gets out. But, so we got Australia today, and we got, I don't remember the first class. Oh, we got Indiana, Marshall. I think they call it Marshall. They say it weird. Marshall County. But, I like the first judge. He sometimes gets pretty annoyed quietly and then just destroys someone very quietly, and you're just like, what did he just say? But I thought that we needed a little bit of international today too. Indiana is pretty international though, isn't it? Isn't it? Come on now. Bobby lives there. When they say it, when Saber says it, he says it Marshall or something, Marshall County. I say Marshall. It would be Marshall County here. Right down the road from me is Marshall Street, not Marshall. Madagascar. I really wish I could have gotten Auckland, but I can't. They just won't let me. I'm going to have to speak to a manager, I think. But, alright guys, thanks for coming out. I'm going to set up OJ, and I will talk to you all soon. Have a good day. Bye.
Radiable prior to that or after?
Okay. You don't know if this was or was not your first homicide case as an evidence technician.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide.